Hello, Jeremy. My name is Chloe and I'm a solicitor here at the firm. Now, it's my understanding that you are a bit pressed for time, so I'll get right to it. I have reviewed your video instructions and will be covering a lot of topics during this initial advice video. So I think it is important that we firstly deal with the issues concerning your previous solicitor before we deal with anything else. Now, when disputing costs, there are two directions that you can take. However, I would firstly like to go through some foundational information. Now, this really should have been provided to you when you initially engaged your original solicitor. Now, based on what you've said, it sounds to me like the solicitor has not provided any indication of costs, which they are obligated to do by law and is referred to as disclosure. This basically means that all costs for their legal services should have been brought to your attention. Generally speaking, your previous solicitor should have disclosed their costs to you and have got you to enter into a costs agreement shortly after receiving your instructions. So this means that at any point your legal costs were to exceed the regulation amount, which is currently $750, you should have been provided with written disclosure. Now, a written disclosure should have included information about what basis legal costs were to be calculated, including any estimates, and a full list of your rights as a client, to receive a bill, written progress reports, to be notified of any substantial changes, and negotiate a costs agreement. If a document, like I have just described to you, was provided, we will require the document to be sent to our office. This will help us determine the most appropriate course of action moving forward. Even if you did not sign such a document, by providing the firm with further instructions after you received a copy, it is likely to be considered that you have consented to the agreement. This is implied by your conduct. However, even if disclosure was provided to you in the beginning, it is not a one-off obligation, but ongoing throughout the matter. Purely based on the information you have provided, I would say that the solicitor has unlikely met its disclosure obligations to you and can be reported to the Legal Services Commission for this type of misconduct. Now, following disclosure, the next step would have been to provide you with a cost agreement. A cost agreement essentially provides you with an offer of costs that is likely to be charged to you for the solicitor's legal services. If as stated, if you either signed or continue to instruct the solicitor, then you have both accepted the offer and consented to being charged at the solicitor's rate. Therefore, one of your possible avenues for disputing costs would be to have the agreement set aside by the Supreme Court or the Queensland Civil and Administrative Tribunal, or QCAT. Where disclosure may not have occurred, the court or tribunal may consider that the costs agreement is not fair and reasonable based on these grounds of non-disclosure and should be set aside or ordered to be void. However, the solicitor can still be paid for their legal work that has been done, and the court and tribunal will consider what amount is appropriate based on the standard scale of costs. To ensure that the costs are fair and reasonable, the court or tribunal will look at the things like what work was carried out and how this work was done, any disclosures that were made or not made, the skill of the solicitor, and the time frame for which the solicitor should have finished or completed that work. So setting aside the agreement by a court or tribunal is option one. Now, this brings me to your second option for disputing costs, which I would advise is the most practical. This is by way of cost assessment. The reason I talked you through cost agreement first is not only because they are generally provided upon retaining a client, but is something a cost assessor would consider. This may be unfavourable to you where you agreed to the solicitor's offer of costs. So now I'll be bringing you back to this concept of disclosure. Where disclosure has not been met, then you may not need to pay legal costs. And the solicitor cannot bring proceedings against you unless and until that cost assessment has occurred. As a cost assessment will come at an expense to you, I would advise that you simply do nothing. And if the solicitor continues to chase you for that money, then let them undertake this process. Now, during the assessment of the cost assessor will consider if the work was done at a fair and reasonable price. In considering what is fair and reasonable, they will look at similar things as we discussed during setting aside a cost agreement, including any disclosures made, the skill and the labour of the solicitor, and the quality of the work that they performed, etc. Once this has been carried out, the cost assessor will either confirm the original amount of the $5,000, substitute a new amount, or reduce the total amount by an amount they feel is appropriate for the seriousness of the solicitor's failing to disclose. If after assessment the costs are not reduced by 15% or more, or the assessor is not satisfied that the law practice failed to disclose, then you would have to pay these costs for the assessment. Now, you mentioned you had not been given any invoice, and you are right to take issue with this. However, the law practice cannot bring any action against you to recover legal costs until 30 days after the solicitor provides a bill to you in writing, and this should also notify you of the rights to dispute disclosure by the ways we've just mentioned. Please check your residential or business mailboxes to be sure that you haven't received these invoices. Even if you have or they've been delivered to you, it may not matter if they do not have a foundation in law to issue it, where no cost agreement has been provided. Now, you also say that the solicitor will not release your parents' will to you because of the outstanding $5 they believe is owing to them. It would seem that they are trying to exercise what we call a lien, or a right to hold possession of documents due to unpaid legal costs. The court have ruled on this issue and confirmed that a will cannot be held under a lien. This is because a solicitor holds a will on behalf of a client upon their death, and upon their death should provide it upon request to those who have a right to the property under the will. Therefore, a lien does not apply. So if you make a request, the solicitor should provide the will to you. However, they do have the right to exercise a lien over their file, which may include instructions and possible wishes of your parents when making the will, and we will require this to be sent to our office once costs have been dealt with. Okay, so now I move on to addressing your instructions in relation to transferring your shares from your sister to your wife. As you and your wife are joint executives, I would be acting for the both of you in the administration of the estate of your late parents. For this reason, I cannot act for your wife in the transfer of the shares, as I would be giving conflicting advice. On one hand, I would be advising your wife as an executor in relation to her obligations in upholding the terms of the will, and in another matter, I would be advising her as a potential beneficiary and her chances of success. This means I could not be impartial in relation to both matters, and would suggest that she seek her own independent legal advice in relation to the transfer of the shares. Now, if a compromise is reached in relation to the shares between your wife and your sister, then I can advise both of you, meaning your wife and yourself, about your ability to effect the agreement as executors, as it relates to your rights and obligations in this capacity, but no further. I am unable to act for your sister in regards to the transfer of the shares, as I am not able to instruct clients concurrently, as it may conflict with my obligations. A solicitor or law practice can seek to act for two or more clients in related matters if the clients are both aware and have given informed consent, and as long as their interests are not conflicting. However, lawyers are cautioned against this, and for that reason, our firm does not deal with conflicts of interest. You also mentioned your sister is disabled. Now, depending on her disability and its impact upon her ability to make informed legal decisions, it may be necessary for a litigation guardian to be appointed on behalf of your sister, or a medical report may need to be obtained confirming her capacity. Either way, it is highly recommended that your sister obtain her own independent legal advice. Even if she is capable, I am unable to act for her because once again, I will be giving conflicting advice, but this time between your wife and your sister in two different matters rather than your wife's two different positions. So that is all the information and advice I have for you at the moment. What I have provided to you today is general advice. And at this point, we have not been retained to act for you. Please advise us if you are happy for us to proceed on the basis that we will only act for you and your wife in your capacities as executors in the administration of your late parents' estate. Unfortunately, as you can appreciate, these processes I have mentioned today will take a fair amount of time and will not be achieved within 3 weeks. The first step in this process for us is to provide you with a cost disclosure and a cost agreement, detailing your rights and at what rate we charge for our legal services, as I mentioned earlier. Please read these documents thoroughly, and if you should have any concerns or require any clarification, please contact our office before signing or providing any further instructions. Until these processes are completed, please do not transfer any monies into our account for these services. As we are not acting for your wife in the transfer of the shares, it would be more appropriate for her lawyer in the transaction to hold the $500,000. In the meantime, if you have not done so already, please make it clear to your previous solicitor that you have terminated your retainer with them. We thank you for providing your instructions to us, and we hope to hear from you.